So I have, great. I've got 11:31. I see all the commissioners and staff and support are here. I'm going to go ahead and call us to order at 11:32. Okay. Everyone has their agenda, and so we can go ahead and get started with the next order of business, which approval of the agenda for today's meeting. I'll entertain a motion.
So move.
All right, a second.
Yeah, I'll second.
All righty, great. All right. So it's been properly moved and seconded that we adopt the agenda for today's meeting. Is there a question to the motion? Question to the motion? The motion is properly before us. All in favor signify by saying aye or thumbs up. And seeing and hearing no opposition, then agenda for today is adopted. We will move on into approval of the minutes of the previous meeting, which was already sent out to everyone. Did anyone notice any errors or omissions? And if not, then I will entertain a motion that we accept the minutes of our July 23rd commission meeting.
Yeah, I'll move.
We have a move on the motion. Is there a second?
A second.
All right, properly moved and seconded that we accept the minutes of the July 23rd meeting. Question. Motion is properly before us. All those in favor signify by saying aye. Thumbs
Aye.
up. Okay. I see and I hear no objections. Then the minutes of the July 23rd minutes of the commission are approved. Okay, and we will call on the executive director now for his report.
Thank you, Chair. Let me share my screen here. Okay, looks like that has, no. Sorry, are you seeing? Yes, you are seeing that. I have before you the mediation program year-to-date report. We skipped that last time because there really was not enough data to show anything of value, but we have here this time the data from the beginning of the fiscal year, July 1st, 2025 to yesterday's date, September 8th, 2025. And so for a little bit of explanation, our mediation program is a key component of our overall process, but in a way it's a separate phase because it's not required of anyone to go through this process. All the parties have to agree, and if it results in a settlement, then we would close out the case, and everyone goes on from there. If it doesn't resolve in a settlement, it'll come back to investigation. So it is truly sort of an optional side portion, but it is a key component of what we do here at the commission. So when I refer to here, I'm saying referrals from the beginning of the fiscal year to yesterday. We had 4 cases go into the mediation process. That doesn't mean that those were mediated or resolved. They're in the process. They may be in the process of being scheduled, but at some point they will either go to mediation or not. The categories down here, so dispositions means that a case has gone through the mediation process, actually being mediated, and that's either in-house with our program specialist on staff, or it could be outsourced to another to an outside mediation center. And so I'll go over the details because we had 3 dispositions, and I can tell you about what happened to those 3. And so those 3 are not the same cases that were referred into the process. Those 3 came into the process in prior months. So we had 2 cases result in a settlement, and we had 1 case result in a non-settlement. And so that's going to go back to investigation. Overall settlement rate year to date would be 2 out of 3, 66.7%. So the 2 cases which did settle, and I can't tell you details because of our restrictions under the Hawaii state law. However, I can give you some general information about those cases. And so the first case that settled was an employment discrimination case that was dual filed with the Equal Employment Opportunity Commission. And it was the primary basis of which was age. And that was settled through the Mediation Center of the Pacific. And the second case that settled was a housing case, and that was dual filed with the Department of Housing and Urban Development. The primary basis for that was retaliation, and that was mediated successfully by our in-house mediator program specialist. And then the final case, which did not result in a settlement, was a public accommodations case. And the primary basis for that was disability, and that went through Mediation Center of the Pacific, again, did not result in a settlement. So year to date, we have 3 of those dispositions, and I'll take you. So I really kind of just summarized everything, but you can see in the chart, Mediation Center of the Pacific had 2 mediations, 1 out of 2 resulted in a settlement. And again, our internal housing case that was mediated, the 1 case resulted in a settlement there. Again, 2 out of 3, 66.7%. So it's early on in the year, and we'll get a better picture of how we're doing overall as the year progresses, but off to a decent start, I would say. So any comments or questions on this before I move on?
No, I just, at some point, whether we need to go in executive session or not, just want to have a quick conversation with commissioners and yourself and others regarding the Civil Beat article and such. So I think it's worthy for us to at least touch on it for just a couple of minutes and acknowledge that we are getting some feedback, and it in that environment, other commissioners may or may not have received or been contacted, and I just want to be transparent, and then we can debrief that afterwards.
I'm fine with that. I'll take your lead on that, Chair. So,
okay. Yeah, so let's go ahead through everything, and then once you're done, let's take about 4 or 5 minutes and go in executive session for that, please.
Okay, sure.
Thank you.
The next report I have here is our caseload report. Sorry if it's making you dizzy here. Okay, so this is, again, as of yesterday, looking at the overall picture of the cases in our system. And so I'll highlight some things here. The biggest, I think, trend that I'm seeing is just in the size of the caseload, and we are, as of yesterday, at 402 open cases. And comparing from last time, that's a total of 17 additional cases in our caseload. And I'll talk about the reasons for that. But you can see here that where we had 26 additional net cases from last time, from 2025. And then we've had also closures from different years as well. So, and this probably relates to, whatever discussion we're going to have about Civil Beat article. We could have that more in-depth discussion. But what I will say also is that in terms of the case aging, so the total number of cases in our caseload is one factor. I think the bigger indicator of how we are doing in terms of processing our cases would be the case aging, and we're looking at especially the top category here, which is the percentage of cases in our caseload which are 2 years or older, and that's the one we really want to keep an eye on. You know, virtually identical to last report, and I've been reporting for many months that that's a number we want to reduce, and one of our main goals is to be fully staffed with investigators and have them trained and have them be able to, you know, tackle cases from all ends. So from intake through investigation, and particularly these older ones. So we can discuss that further, I think. So that's up there at 37%. The breakdown by type of case, pretty similar to last report. I think we had a number of cases. If you look at the response monitoring category here, so this is where we have cases filed, and then we request or require a response to the allegations from the respondent or respondents that are named. And so I did notice that we moved quite a few cases out of the response monitoring phase to other parts here, probably pending. So that's a good thing. That shows that you know, we're not only filing cases, but we are also successfully getting responses from the respondents. And then once that's established, we can move on to further parts of the investigation. And so I think the only other thing, let me see, and I can field questions after this, is, okay, this fiscal year comparison we talked about last time, that does not change until we actually issue our annual report to the public. And then we'll add on a whole column of data, and we can make some comparisons at that point. What I've been discussing, though, and I can tell you, is that we have steadily increased over the past few years our numbers of pre-complaint questionnaires received up here. And so that reflects just the public coming out of pandemic and really filing more complaints or inquiries at least. So I think we'll have a number higher than this when this new column is added. And then going further down to our year-to-date comparison. And these are limited numbers because we're just talking about a couple months, but I do see some trends in line with what we've been reporting, particularly when we look at the pre-complaint questionnaires received. So we were down back, 2021, 2022, and then we increased considerably in 2023. And now, if you take a look at the current fiscal year, it's 155 pre-complaint questionnaires that we've received. So that's just the public coming to us and seeking our services and seeing if they have a complaint that's jurisdictional. That ties into, the intake decision numbers. So that means 130 year-to-date cases have been, the pre-complaint questionnaires have been worked on, and there's a decision made as to whether or not it's a jurisdictional complaint. And then, the decision is to either take the complaint or not based upon jurisdiction. So 130 is a pretty high number, as well as you would see here complaints filed. So 59, that's high compared to the previous year-to-date numbers. And so I think one thing that I would point out is that in terms of our overall numbers, so open cases, what we really need is that we file complaints as they come in, as the PCQs come in, and then we also close cases at the same or a higher rate. I mean, that's the only way that we're going to reduce our caseload. So again, the total number in our caseload, it does indicate something, but it's not the full picture because, I mean, we don't have full control over the numbers of PCQs that come in, and we don't have much discretion as far as having to devote resources at the front end because we do have time limits in which we can file these complaints. So that's what we tend to do is we tend to, make sure that all those PCQs turn into complaints, the ones that are jurisdictional, while at the same time devoting our other resources to investigation of all cases in our caseload. So that's the report I have, and I can field any questions, and we can also have that separate discussion.
So,
Oh,
Marcus,
go ahead,
I'm
John.
just, sorry. Yeah, I have a question. So
Sure.
what, can you give examples of when you decide to not take on a complaint or a case?
Yes, I can. It's actually not a decision. It's a determination on whether or not there's jurisdiction. So someone may come to us and they feel they have a complaint that is discriminatory under our laws. And it could be that it simply is not. I mean, they may have a workers' comp issue that's outside of our jurisdiction, or they may have some issue that is not related to a protected basis that we cover. So that's one thing. We also have time limits in which to file complaints. So if someone came to us and a thing happened to them, but it was, say, 2 years ago, we just don't have the jurisdiction at that point to take on the complaint. We might make a referral if it's still within some other time limit out there. But as far as we're concerned, we look at the statute of limitations period that we are authorized to take complaints within. Other than that, I mean, as long as someone comes to us and they allege that they were harmed in a way that falls within our statutes, so employment, housing, public accommodations, access to state services, and then whatever that action is allegedly tied to a protected basis of theirs, we typically would have jurisdiction, and then we would draft the complaint. And as long as the person coming to us does sign the complaint under penalty of perjury that what's on the complaint they believe to be true, then we take the complaint. So it's not a choice, really. It's sort of just determination of jurisdiction.
Well, it's not often the case where the complaint is ridiculous and you decide to not take it on.
Well, I mean, ridiculous in the sense that if it's simply not covered by a statute, it's not a choice. We would make a determination whether or not it falls within the statute in terms of the subject matter and the allegations. So that would be the determination there. I think there's only a rare instance where someone might allege something that clearly is not credible, and it has to do, maybe dealing with aliens or dealing with, things that are just not reality. In that circumstance, yes, we can exercise discretion not to take a complaint, but that's rare, but that may be an instance you're thinking of. Yeah.
Thanks.
Yeah.
Okay, any other questions? If not, then if it's all right with the commissioners, let's take about 4 or 5 minutes and go into executive session just to speak freely, and then we'll make sure that we are transparent when we come right back out. Okay? All right, can you change us over? Okay. All right, so I'll yield the floor to council for debrief.
Okay. So during executive session, we discussed the hiring of an additional hearings examiner to help with the number of cases being docketed. And the commissioners have appointed Joanne Adams to help with the hearings and to serve as a hearings examiner.
Okay.
And we also had discussion, but we will allow the commissioners to move and vote in open session regarding an extension of time to hold the contested case hearing. I've reviewed the record and believe there's good cause for this motion.
Okay, commissioners, you have heard council's recommendation on granting an extension to hold this contested case hearing. Is there a motion for an extension?
So moved.
All right, is there a second?
Second.
It is properly moved and seconded that we would grant an extension for this particular case. The motion is properly before us. Question. All those in favor signify by saying aye or raise your hand. Okay, I see and I hear no objections, and so the request is approved. Council, you have anything else for us?
No, thank you.
All right, and
Actually,
go
sorry, I
ahead.
realize I may have not been clear for the extension of time. I am asking for a 6-month extension for us to hold a contested case hearing. So I apologize for that. So that would
Okay.
be until May 30th, 31st, 2026 to hold the contested case hearing in Payne v. Wagner.
Okay, so just to be clear, May the 31st, 2026, I'm going to ask for unanimous consent. Commissioners, is there any objections? Any objections to that approval for 6 months to clarify that it is May 31st, 2026? I see and I hear no objections, and so it is that is approved. Okay. Anything else, Council?
No, thank you.
All right. I will go to Executive Director for conclusions. If there's anything else that you have, sir? If nothing else, then I
Nothing
will
else.
now move. Okay. We'll move on to any potential legislation and rulemaking.
Okay, so a member of the public, and I believe he is on today, Peter
Okay.
Frick. He has contacted our office about possible rulemaking regarding public accommodations. And specifically, there was a bill that this past legislative session, Senate Bill 1496, relating to discrimination against persons with disabilities and public accommodations that use digital technology or digital communications. And every year there's a different version of this bill, but it hasn't passed so far, but it's getting to the point where it might. I'm not sure if Peter Fritz would like the floor to discuss a little bit background. He has much more information than I do. Um,
I'm the life of
Okay.
the party when this topic comes up.
Go ahead, Peter.
But it's while similar bills have been proposed to provide additional accessibility, this bill for SB 1496 was much different. To lay a little foundation, the Department of Justice adopted rules in November of 2024, which said we will be looking and guidance of recommendations at these particular factors to determine if something discriminates. The standards were the Worldwide Access Group, WAG, Standard 2.11. They were adopted, they were published first in 2018. So somebody took this and said, we're going to put what our recommendations in the law. The bill had a bunch of flaws because it didn't incorporate all of the exceptions that the Department of Justice had. One particular problem was it said that the standard would be 2.11 as amended. The problem is that 2.12 is already out. These are standards, and if I get too technical, please let me know. I'm a tax lawyer, and numbers kind of make me comfortable. And so what it would have meant is when the law went into effect, that I could put on my black hat and go and sue all sorts of websites because they don't comply with 2.12, which is the newest standard, but it's been adopted by no one. So there were also exceptions in the Department of Justice's regulations, which gave specific instances when these new standards wouldn't apply. And 2.11 pretty much applies to the new technology, apps, and other things. But the reality is that there's nothing that would have prevented a plaintiff from bringing these up before the court and letting the court decide if they should be applicable in these particular circumstances. My position is they shouldn't be in the statute because they're guidance, they're recommendations, they're not written in stone. They should be adopted in a manner that was similar to what the Department of Justice did, which would be regulations. Regulation can be changed, regulation can be amended if certain things change. And so that's the proper way, in my opinion, to move forward. This bill got all the way to conference committee. But if you read my testimony on the bill, you'll find I raised a whole bunch of issues, and I'm not sure it made it through conference. But the original bill as drafted was just kind of, well, 2.11 is new and it's better. Therefore, we should put it in without anybody ever reading the statute, the bill. And if you read the testimony, you have agencies saying, oh, this will be great, and this is what we're going to comply with. The difference is that this bill applied to websites. So if you have your own personal website, it applies to you, but it doesn't apply to the state. And so I don't think anybody really looked at the bill other than me, and that shouldn't be the case. But that's a bit of a background. I don't want to take too much of the committee's time, but I'll be happy to answer any questions. But I wanted to lay a little bit of a foundation. I guess the final statement would be that these regulations do not have to be adopted by the Hawaii Civil Rights Commission, because they can always be introduced in court as an example of and to prove that there is a discriminatory intent. I don't know what will move forward with the bill, but they shouldn't be in the statute, and that's my position and the way I will testify on this bill, along with the fact that there are no exceptions and circumstances under which these rules wouldn't apply. So I'll be happy to answer any questions.
Mr. Fritz, just so that in the clarity of public folks that may not be attorneys listening, is there a succinct request that you have for the commission with respect to either support or not support of this particular issue?
My position would be that the commission itself should consider promulgating rules and follow the path that was set forth by the Department of Justice. And those rules would include exceptions and other paragraphs and information in the Department of Justice's rules. I actually attached a modified Department of Justice rules for as a proposal for the in my testimony, I should say. So there is a particular guidance, but the issue before the board is which path should it follow? Should it follow the bill if it's introduced in its same form next year, or if it's moved forward, or should it decide to promulgate the type of rules and follow the path that was established by the Department of Justice? And yes, I'm a lawyer, so this is a brief statement. That's a joke.
I appreciate that, sir. And again, I appreciate you wanting to make it simple for the listeners and layman's. And so I appreciate that. And so with that, thank you for your testimony today. That will certainly be taken under advisement. And counsel, is there anything else with respect to potential legislation?
No, I do want to mention that we don't have any administrative rules yet for public accommodations. Our statute is found in Hawaii Revised Statutes 489. And this particular issue, I think, is a very important one that would have to be addressed either by, legislation or rulemaking, because it deals with, emerging technologies that, customers, guests, or visitors to public accommodations, which are businesses, restaurants, movie theaters, use to interact with their customers. So for instance, if you've been to a restaurant lately, they all have QR codes. Are they accessible to individuals with disabilities? And another issue is a lot of businesses are now moving completely online or digital. They don't always have a brick and mortar storefront. Do we have jurisdiction over those? Because the way public accommodations law was traditionally, analyzed was, well, do they have a storefront? That type of thing. So I do think it's an issue that we would want to address and think about, at least in the back of our minds. And I know we only have 4 commissioners right now, 5, when we're fully staffed. But if we are looking at potential rulemaking or legislations, we can look into a permitted interaction group, which would not require us to have quorum, but 2 commissioners could meet to discuss potential rulemaking or potential legislation. So that's an option we can think about, maybe put it on our next agenda if we want to think about that a little bit more. So those are our options.
Thank you very much. Commissioner Mueller, did you have a?
Yeah, I was gonna ask Connie. Connie, is this a bill that was one of the ones we commented on or no?
I was on maternity leave during legislation.
Oh.
I believe, yes, we supported it. This was a bill that we supported.
Okay.
This is Peter Fritz. Yes, the HCRC did do that. I spoke to Mr. Kawakatz. I spoke to the executive director and told him about the possibility about writing administrative rules. And the HCRC did submit some testimony, but not specifically taking a position either way, one way or the other. The testimony for this bill is all online, mine as well as the HCRC's. But if you'd like, I'll be happy to send you at your peril a copy of the testimony that I put in along with a very quick mock-up of some administrative rules, and I'll be happy to send that to you or to Mr. Nashiro. Thank you.
Thank you, Peter.
Thank you.
Okay, any further questions by the commissions? Okay, I don't see or hear any. Okay, anything else for potential legislation I don't see on the agenda? So with that, we will move on into some general discussions. And again, for this and in the interest of time today, we're just going to, we did have an executive session and I discussed what we did address in that regarding the Civil Beat article. And again, I think what we want folks to go away today with is, with respect to structure and duties and such, is that we are committed to civil rights. We do have an awareness of the fact that given the temperature across the nation, that we stand at the forefront as an organization, as an aid and assist. We're realizing that it's becoming more and more difficult for individuals to have legal redress in these economic times. And so we are here for you, and we're going to make sure that we stay committed to you and the defense of your civil rights. Okay, with that, I'm going to move to public statement. Raymond is here and wants to address the commissioners. So Raymond, you have a few minutes. Thank you.
Yes. So good afternoon. My name is Raymond Sin. I'm active duty United States Air Force, formerly a high school teacher on the 9th Island, Las Vegas, Nevada. I wanted to take this time to really give my perspective on a few things, military, law, education, as well as importance of digital literacy. This month, the month of September, Lieutenant Governor Sylvia Luke has made it an initiative to emphasize digital literacy. It's also Native Hawaiian History Month. And to your point, Mr. Braggs, the civil rights movement has a long, long history with the state of Hawaii. I was actually at the Office of Hawaiian Affairs, and the chair gifted me this book by a pastor, Light Upon the Mist. It's called, I think it's The Sinews for Racial Development. It's quite a short read. I highly recommend it. It's free on public archives or internet archives. It's by Akaiko Akana. Excuse my pronunciation. I'm from the state of California. He's of Native Hawaiian and Chinese ancestry, was a Christian minister, I believe, at just down the street from here at the Punch Bowl I think it's called Kawaiho Church. And this is where actually I wanted to mention some of the history. Reverend Abraham Kahikina Akaka, he was the one who gave the Hawaiian traditional lays to Dr. Martin King Jr. And we want to emphasize this as an importance to the next generation of leaders here. I myself was a student of many descendants of the 442nd Combat Regiment Team, U.S. Army, as well as the 100th Infantry Battalion. Currently, I'm working with Miss Claire Matani here of the 442nd Legacy Center in Macaulay, and really trying to make sure that's still aware that everything that's been given to us, a lot of it stems from military, and then eventually to either social, economic, political, and legal rights up to the point of where we are now. I myself grew up in the 90s in California. My mother was born in Hong Kong, and she came here as a result of the civil rights movement and the Rights Act of 1964, as well as Lyndon B. Johnson's Nationality and Immigration Act of 1965, which opened up immigration to parts outside of Northern and Western Europe. I want to also emphasize during that time, the Japanese American internment camps here in the state of Hawaii, they were, or at least the territory at the time, they were thinking about sending these Japanese Americans to other islands in Hawaii, as well as to the internment camps on the mainland. And 1924, McKinley High School, a lot of amazing people graduated from that class. From my understanding, Senator Daniel Inouye, as well as the first Harvard law-educated attorney, Masaji Muramoto of Japanese ancestry. And it all took a village. During that time, there was a business leader, Chinese American named Hung Wai-ching, the founder of Aloha Airlines, formerly known as Trans-Pacific Airlines, as well as the University of Hawaii Regent. There was Shigeo Yoshida, as well as Charles Loomis, and he worked with the military authorities such as FBI's Robert Shivers and Charles Hemingway. And they were instrumental during that time because during Pearl Harbor, there was actual military martial law, and a lot of these civil liberties were actually abruptly taken from civilian courts to martial courts. I wanted to really also emphasize how the 442nd has really impacted the rest of history in terms of civil rights. So Patsy Mink, Congresswoman Patsy Mink, 1972, the Equal Opportunity in Education Act, it provided, as an educator, I really take this to heart, it allowed for non-hostile and guaranteed non-hostile environment in the education environment, just like the civil rights does for the workplace environment. So I really wanted to emphasize that. I think Hawaii and the civil rights movement have been kind of hand in hand. But again, I'd like to have your support and sort of having more education and recognizing the legacy of Senator Daniel Inouye, as well as the 442nd Combat Regiment team. I myself am not an attorney, but just something I'm interested in education. You have so many things you have to take care of. And unfortunately, sometimes it's also actually defending students in terms of potential mass shootings as we see the past few weeks and months. So I'll leave it at that. I've enjoyed my time here, being stationed in Pearl Harbor, being in the military for the past 2-3 years, and hopefully that some of the things that are past kapuna, as they call it, the ancestors and the wisdom of the past, the mahalo, the gratitude we have for them in the state of Hawaii and the traditions of Hawaii can henceforward bring us to a better future of civil rights for everyone. Thank you for your time.
Thank you very much, Mr. Sin. And let me just say that I speak for all when I say, first of all, thank you for your service. This is definitely a time that we are living in where we have got to make sure that we give honor and respect to those who wear the fiber of this nation. as one who spent 26 years, 9 months, and 11 days in uniform under some very arduous situations. I appreciate those who are continuing to carry the fight for freedom and democracy forward. I also want to commend you for being an educator and a commitment to future generations who one day may ultimately grow up and decide to be attorneys or commissioners or join in this fight for civil rights in multiple capacities. Thank you for the Air Force allowing you to have Hawaii on your tour of career. And hopefully that you will have this passion that is emanating in your voice here today. You'll continue to carry that forward, and you will see value in doing that wherever you next land and are housed. And I would say to you that you stroked some nerves and some chords there when you spoke about the 442nd. You spoke about the great leaders, the passion and the commitment of those who paved the way. Patsy Mink in Title IX and the Civil Rights Act of 64, voting, all of that of 65 and many others, and the role and the sensitivity that we as the one state in the nation truly are mindful of what happened with the Japanese and their commitment and the internment, and why the fight for civil rights is so important. And even today, how important the preservation of history is for those of us who are in civil rights. So I want to commend you. I appreciate you taking the time out of the day and just giving us a reminder. We wish that more folks would do that with such passion. So we wish you all the best. Thank you very much. Commissioners, I will go ahead and move the agenda now. And I think we're at item 7, where we're going to consider our next opportunity for a meeting in October. Tentatively, we will consider the 14th of October at the same time, 11:30. We will send out an email to ascertain if that works for everybody, with the goal to try to be done by 1 p.m., if not sooner, because that fits well into my calendar. But tentatively, we're going to look at October the 14th at 11:30. And Sandy will get that out to you, and you'll just confirm up with her. Okay. And we don't have a fixed date yet. Staff can correct me if I'm wrong on the public training on amendments to the administrative rules.
No, that's
Is that-
correct.
Okay.
But we have decided that instead of a live public meeting, we might just do a video so people can refer back to it, just of the overview of the new rule amendments.
Okay. Thank you very much. And we will definitely get that out to the public. We should have something firm up on that at our next meeting. Okay. If all hearts and minds are clear, we are at the top of the hour. Is there any unreadiness, commissioners? Staff, have I overlooked any other administrative item for us today? If not, I really want to thank you for your time and your commitment, wishing you continued health and wellness. We're grateful that the storm took a turn and that we are spared. And so I will ask you to continue to press on, and let's continue to fight for civil rights for the folks here in Hawaii and continue to be that standard bearer. With that, I will entertain a motion that we adjourn.
Yes, move.
All righty, then I see concurrence. Everyone's coming off. All right, folks, I'm going to go ahead and say that we are adjourned at 1 p.m. until we meet again October 14 tentatively. Have a great day. Take care.
Thank you.
Thank you all.
Thank you.
Take care, everyone.